LawSikho's thorough newspaper analysis for 14th of October 2023. Now, we'll start with the editorial session. We'll be giving an update to you on the 26-week pregnancy case that is going before the Honorable Supreme Court, that we have covered toys in our TNA in the legal news update. So if you want a legal perspective of this particular editorial, then you can watch our previous TNAs. We have brought this particular editorial today in this particular topic. Then we'll be discussing about some news update, and lastly, the legal news update coming from the Honorable High Court and the Supreme Court of India. Now, in Supreme Court questions of foetal viability and rights of unborn child. So let us discuss about the context that I'm talking about first. It is the request that is given by a married woman to end her 26-week pregnancy before the Honorable Supreme Court. So there was a petition which was filed by a married woman who was 26-week pregnant, and he sought an for termination of pregnancy. Now, the case traveled to the two benches of the Honorable Supreme Court, raising the crucial questions on the decision of autonomy of a woman to abort and the legislative framework. So what is the autonomy and what is the accountability of the woman that who can adopt, and what is the legislative perspective? What does the Medical Termination of Pregnancy Act states on this particular situation? So let us start. So he was the woman was a 27-year-old married woman, and she told to the court that the pregnancy was unplanned. First, secondly, she told that her family income is not that sufficient to support the another child, and she is under the medication of postpartum depression after the birth of second child. So she stated three grounds that the pregnancy was unplanned. I am going through depression medication, and thirdly, the family income is not sufficient. Now, on October 9th, the two-judge bench, which was led by Justice Hema Kohli and Justice B.V. Nagaratna, interacting with the petitioner through video conferencing, stated that the termination of pregnancy is allowed. So before the two judges bench of the Honorable Supreme Court, they allowed the termination of pregnancy, and the court reasoned that unwanted pregnancy due to failure of contraceptive method is the same as forced pregnancy. So they they equate this particular situation as forced pregnancy, for which termination is allowed up to 24 weeks. However, at the second perspective, AIIMS Delhi wrote to the Honorable Supreme Court that they would need a directive on whether stopping the foetal heart, that is, can be done before termination, since the fetus is currently viable. Viable means he is ability to survive. What is vital? Currently viable means that the particular fetus has ability to survive. That particular fetus can survive. So AIIMS Delhi wrote to Supreme Court that they would need a directive on whether the stopping of that particular heart can be done before the termination or not. Now, again on October 11, under the AIIMS report, so October 9, the judgment came that the termination is allowed. On October 11, on the base of the AIIMS report, the same bench split on allowing the abortion, and the case went before the three judges bench. So there was two judges bench first, Hema Kohli and B.V. Nagaratna. Then they got split after the AIIMS report. Then the particular case went to the three judges bench, which was headed by CJI D.Y. Chandrachud. On Friday, the bench called for a fresh medical report to indicate the fetal health and medical condition of the woman. So after that, when the matter went to the three judges bench, so the Honorable Supreme Court asked for a fresh medical report and the medical condition of the woman. Now, this is all about the facts of the case and the issue. So facts are that she is a 27-year-old married woman and a 26-week pregnant, and she wants to terminate the pregnancy on various grounds. And the matter went to the two judges bench and the three judges bench on the base of the AIIMS report. Now, the Medical Termination of Pregnancy Act allows termination of pregnancy in three stages. What are the three stages? Termination of pregnancy up to 20 weeks is allowed on the advice of one doctor. So if the fetus is of 20 weeks, so it is allowed on the advice of one doctor. If it is of 20 to 24 weeks, The right to seek abortion is determined by 2 registered medical practitioners as an exception, but only under certain categories. So if the fetus is of 20 to 24 weeks, it is allowed under circumstances only. Now, there's section 3B under the MTP Act lists 7 categories of forced pregnancies, including statutory rape in case of minors or sexual assault, women with disabilities, or where there is a change in marital status of women during pregnancy. So there is a rule in the Medical Termination of Pregnancy Act which lists the 7 forced categories of pregnancy where the termination is allowed. Now the condition is after 24 weeks, if the person needs to terminate the pregnancy, a medical board must be set up in approved facility which may allow or deny the pregnancy only if there is a sustainable fetal abnormality. So the condition is 20 weeks stuck, advice of one doctor, 20 to 24 weeks stuck, 2 registered medical practitioner under only certain categories, and after 24 weeks approved facilities के साथ एक medical board बैठेगा which may allow or deny termination of pregnancy. This is a condition and this is the legislative perspective of the Medical Termination of Pregnancy Act. Now, has the court allowed termination beyond 26 weeks? Let us see this. Yes, in many cases, court has allowed a termination after 26 weeks. On August 21, the bench was headed by Justice Nagaratna, held a special sitting on Saturday to allow the termination of pregnancy of rape survivor whose pregnancy was at 27 weeks and 3 days. So there was a rape survivor and the termination of pregnancy was allowed in 27 weeks and 3 days. However, the difference here is that the marital status of the woman. Here in the present case, the marriage is done. She's a married woman. Secondly, the conception happened in the consensual sex, and it was not a forced pregnancy. Now, in September 2022, the bench led by Justice Chandrachud allowed abortion of an unmarried woman who was 24 weeks pregnant and was in a consensual relationship. Now, the court stated that the law must remain cognizant of the fact that changes in society have ushered in significant changes in family structures. Okay, so there are also instances in which court has allowed the termination of pregnancy after 26 weeks. Now, one more right comes here in the picture is what about the unborn child? So the observations which came in this particular case by Honorable CGI Chandrachud said that the right of women must trump when it comes to abortion and the need to balance out the right of unborn child. So the court state that the right of women should be trumped. Okay, it should be given a priority. There is no doubt that our law is far ahead of other countries. We will not have a Roe versus Wade situation here. Our law is liberal and pro-choice. So it's a very revolutionary, statement coming from the Honorable Chief Justice of India that our law is very proactive. It's very liberal and it has given rights of women priority. Now, while the courts have read the Medical Termination of Pregnancy Act liberally, the test of fetal viability as a benchmark to allow abortion is new in India. Fetal viability means ability to survive. So it's a law which is new in India. There was a landmark judgment in the US Supreme Court verdict in Roe versus Wade in 1973 that made abortion a constitutional right and allows abortion up to point of viability, that is the time after which a fetus can survive outside the womb. Okay, fetal viability in 1973 was pegged at 28 weeks. Now, with the scientific advancement, it has reduced to 23 to 24 weeks. Now, the criticism of India's law is that the decision to terminate after 20 weeks is shifted to doctors and not the women. Just say I told you before also, between 20 to 24 weeks, if you want to terminate, we need a registered medical practitioner, two registered medical practitioners permission. Now, while this aspect is not challenging court, frequent case of women approaching the court at the 11th hour point to a legislative gap. Now, Indian legal framework on reproductive right tilts to the side of women's autonomy to decide and choose more than towards the right of unborn child. Now, in the case of 2005 Rajasthan High Court, in Nanda Kishore Sharma versus Union of India case, it rejected the challenge to the constitutional validity of MTP Act on the ground that it violates the fundamental right to life of an unborn child. Now, the Rajasthan High Court also recognized the right of unborn child. The right of unborn child has, however, formed the basis of legislation that deal with succession or the law banning sex determination of foetus. Section 416 of Cr.P.C also provides for postponement of the death sentence awarded to a pregnant woman. So it also provides for the postponement of a death sentence which is awarded to a pregnant woman. So there are many rights for unborn child. It's a legislative perspective that has also come up in Rajasthan High Court. And we have a US Supreme Court case also. Now, let us see how this particular development goes further and we'll keep you updated. Now, let us come with the national news of the day. Sivasankari honored with 32nd Saraswati Samman. Noted author and activities, Sivasankari has honored with the prestigious Saraswati Samman for the year 2022 in Tamil Surya Vamsam at National Museum in Delhi. So, about the recipient, let us see. Sivasankari literally career plans over 5 decades. She is an author of 36 novels, 48 novelists, 150 short stories, 15 travelogues, 7 collection of essays, and 3 biographies. About the award, Saraswati Samman is instituted by K.K. Birla Foundation, carries a plaque, a citation, and a cash prize of 15 lakh rupees. Sivasankari is the 32nd recipient of this Saraswati Samman award, joining a pantheon of letters over the years. Now, the selection follows a rigorous 3-tier process leading to up to final decision by Chayan Parishad, currently headed by former Supreme Court Justice Arjun Kumar Sikri. So, this is about the award and this is about the awardee, about the recipient who received the award. Now, PM inaugurates 9th G20 Parliamentary Speakers Summit. The PM has inaugurated 9th G20 Parliamentary Speakers Summit at Yashobhumi, New Delhi. The summit was hosted by the Parliament of India under the broad framework of India's G20 presidency with the theme of Parliaments for One Earth, One Family and One Future. So PM has inaugurated. The summit is a Mahakumbh of all the parliamentary practices from across the globe. Now, let us understand the background of it. In line with the theme of India's G20 presidency, the theme of 9th P20 Summit was Parliaments for One Earth, One Family, One Future. The speakers of Parliament of G20 members and invitee countries attend the event. A pre-summit parliamentary forum of life, that is Lifestyle for Environment, was also held on 12th October to deliberate upon the initiatives towards a greener and sustainable future in harmony with the nature. So PM has inaugurated 9th G20 Parliamentary Speakers Summit in New Delhi. Now, Jharkhand Animal Husbandry and Dairying Department launches a help program. So they have launched a help, which is accredited agent for health and extension of livelihood production program in the state of Jharkhand, heralding a new era for women's participation in livestock sector. Now, it is designated to empower a woman by engaging them at accredited agent responsible for disease control, animal tagging, and livestock insurance. A help initiative which is already underway in various states and UTs, including Bihar, Gujarat, Jammu and Kashmir, Karnataka, Madhya Pradesh, Uttarakhand, Jharkhand, was initiated through a memorandum of understanding signed between the Department of Animal Husbandry and Dairying and National Rural Livelihood Mission under the Ministry of Rural Development and Government of India. So this was all about a help program that is launched by Jharkhand and has been previously launched by many states. It is the particular program is launched for the women empowerment in livestock sector. Now, next, Neeraj Chopra joins elite list of Laureus ambassador. Neeraj Chopra is an Olympic and a world javelin champion, was named as a Laureus ambassador on Thursday. He is 35 years old and is the second Indian to be named as Laureus ambassador after former cricketer Yuvraj Singh was honored in 2017. Okay, so Yuvraj Singh was also honored with this in 2017. Laureus is a global sports-based charity that works to improve the lives of young people. ठीक है? The organization leverages its Sports for Good initiative, the World Sports Academy, the Ambassador Program, and the World Sports Award to harness the inspirational influence of sports as a catalyst for positive change. Chopra is the only third Indian after wrestler Vinesh Phogat and cricketer legend Sachin Tendulkar to be nominated for Laureus Award. ठीक है? So Laureus ambassador Neeraj Chopra joined in the elite list. Manikanta creates new 100-meter national award. Manikanta HH of Services created new men's 100-meter national award on the opening day of National Open Athlete Championship. She is a 21-year-old, clocked 10.23 seconds to win the heat number 3 and qualify for the final. So Manikanta creates new 100-meter national award. Hurun India Rich List 2023, Radha Vembu is the richest self-made Indian woman. Shri Radha Vembu, Zoho Corporation co-founder, has become the richest self-made Indian woman, surpassing Falguni Nayyar, founder and CEO of Nykaa, according to the report by Hurun India. Zoho Corporation was co-founded by the older brother Sridhar Vembu, who started the business initially in 1996. Radha Vembu ranked 40th among India's 100 richest person, while Falguni Nayyar ranked 86th. What is Zoho? Zoho is a beta testing a WhatsApp alternative called Aratai, which means chat in Tamil language. So it's a social media platform. Radha Vembu's education, born in 1972 in Chennai. Radha Vembu did her schooling at National Higher Secondary School in Chennai and then went to Indian Institute of Technology, Madras for education. So Radha Vembu becomes self-made richest Indian woman and ranked 48th in the list. International news, Putin visits Kyrgyzstan in first foreign trip since ICC arrest warrant. Russian President Vladimir Putin held talks in Kyrgyzstan on Thursday, a Central Asian nation with strong ties to Moscow, during what was his first foreign trip since the ICC issued an arrest warrant for him in March. Now, the Russian leader is also due to travel to China next week for the Third Belt and Road Forum in Beijing. Neither Kazakhstan nor China are members of the ICC, which was established to prosecute war crimes. The US imposed sanctions on 4 Kazakh companies in July for re-exporting electronics components and other technology to Russia. Kyrgyzstan Central Bank last week urged local banks to tighten control over compliance with Western sanctions against Moscow. Now, the legal update coming from the Kerala High Court in the case of Raju J. Velatu versus P.V. Alexander and another unconnected matter. It states that it is based on 313 Cr.P.C. Failure to question accused under this particular section vitiates entire proceeding. So the court has stated that in every inquiry or trial, for the purpose of enabling the accused personally to explain any circumstances appearing in the evidence against him, the court shall, after the witness for the prosecution have been examined and before he is called upon his defense, question him generally of the case. The court stated that the intent of this provision is to align with the principles of natural justice, particularly that of audi alterum partem, which provides that both sides must be heard. So this particular section, guys, you will receive maximum questions in the judicial services examination in mains paper on under 313 Cr.P.C. So it's a phenomenal judgment coming from the Kerala High Court explaining the jurisprudential essence and the intention of the legislature, that why this particular section is being framed and drafted, and how this particular section is based on the principle of natural justice. Now, this is all about the today's TNA. Thank you for watching and take care.